That's right. I think we're ready to carry on.
Our next witness is, so my apologies, Mr. Peters. Commissioner, I will start again. Our next witness, and our witness this afternoon, is Dr. Daniel Orlando Smith. Before I commence questions of Dr. Smith, can I just introduce the representation? That is, we have this afternoon, on behalf of the Attorney General and the elected ministers, the Solicitor General attending remotely. That's Miss Joanne Williams-Roberts. And then Mr. Richard Rowe attends on behalf of a number of members of the House of Assembly, and that is again remotely. Dr. Smith has legal representation, and that is Mr. Dennis QC of O'Neill and Webster. Unfortunately, Mr. Dennis, who's attending remotely from Jamaica, appears to have lost his connection. Hopefully that will be restored, but Dr. Smith has indicated that he's content to continue in the absence of his legal representative.
We hope Mr. Dennis comes back to us shortly.
I hope so. Thank you, sir.
Dr. Smith, can I begin by thanking you for returning to give further evidence to the Commissioner? You made an affirmation on the 13th of June, which was the first time that you gave oral evidence to the Commission. You're still bound by that affirmation, and so there's no need to take it again. Okay. There are some bundles to your left, which contain documents relevant to the issues that we will be going through today. And so I'll take you to them as we need to. You also have some loose leaf documentation there on which we'll again need to look at. Could I ask you please, Dr. Smith, if you could just keep your voice up so that we can make sure that your answers are accurately and clearly recorded.
Can you hear me now?
The microphone unfortunately doesn't amplify.
Okay.
And so it's perhaps, I think probably the tip is to speak even more loudly than usual. The other thing we both need to guard against is speaking across each other. That can happen, and if it does, I will stop and allow you to finish your answer.
Okay, thank you.
You've been asked to return this afternoon just to deal with two matters. First is what we have been discussing or describing as the BVI Airways project. And the second is the port development project, both of which took place during the time that you were Premier and Minister of Finance. So what I'll do is, if I may, I will take those each in turn and separately. So if we could just deal, Dr. Smith, with BVI Airways first of all, to give some context to what will follow. On the 10th of September, the Commission sent you a warning letter, which is historically described as a salmon letter, and which set out potential criticisms which arise from the evidence obtained by the Commission in relation to the BVI Airways project. The criticisms, or the potential criticisms, arise in relation to you as Premier and Minister of Finance. I should explain that they do not constitute either the provisional or concluded views of the Commissioner. The purpose of such a letter is to ensure that you have proper notice of potential criticism so that you can respond to them, and you have done so. You have provided a written response to the Commissioner, which, if I may say so, is particularly helpful because it might be the first written response we've had that uses numbered paragraphs, which always makes it easier to navigate a document. Right. You have annexed to that, as your appendix 1, the witness statement that you made for the purpose of an arbitration in which the government of the Virgin Islands was involved against various the operator parties in the BVI Airways project. Now, if I can explain, Dr. Smith, whilst the Commissioner will have read the witness statement, it's accompanied by a significant number of exhibits which have reached the Commission, but which we haven't had proper time yet to go through carefully. So it may be that if there are additional questions that the Commissioner wishes to be put to you, that we can do that in writing in due course. But can I confirm firstly, if you go to the last page of your written response, please, which is at your paragraph 28, Dr. Smith. Can you confirm that on that last page, it's dated the 24th of September 2021, it carries your signature?
Signatures.
It's the sort of the last page before
Yes,
you
yes,
reach the
it
appendix.
does, yeah.
Thank you. And can you also confirm, please, that you are content that your written response together with the exhibit should form part of the evidence before the Commissioner?
Yes, I am.
Thank you. Given the detail that you have provided both in your response and the detail that is contained in the appended witness statement, which gives some additional background, what I would like to do this afternoon, Dr. Smith, is just to focus on some additional matters.
Okay.
So I'm not proposing to read out the entire document, but I will try and summarize it as we go along. If I could therefore turn to paragraph 5, please, of your written response. The first potential criticism that arises relates to the manner in which the BVI Airways project was implemented. And what is said is that there was a complete bypassing of the tendering process, which was inconsistent with the principles of good governance and meant that the project is unlikely to have achieved best value for money. If I could summarize your response, which is set out at paragraph 6 to 9, your position, if I have understood it correctly, Dr. Smith, is that this was not a project where the government of the Virgin Islands which the government of the Virgin Islands had to put out to tender, because it was neither for a purchase of goods nor of services. I hope that I've summarized that fairly, but could you explain what your understanding, please, was of what the arrangement was that the government of the Virgin Islands was entering into with BVI Airways?
What we were doing, what the government of the Virgin Islands was doing, is giving a subsidy to an airline to carry passengers to the British Virgin Islands, a subsidy for this process. It is a similar subsidy that most Caribbean countries get into with various airlines. They give a seat subsidy in order to get the airlines to bring the passengers to their destinations.
In this case, and you have in your written response and in the witness statement you made, drawn a distinction between the 2014 project and the 2015 project, the 2014 project being the one that you rejected.
Correct, yes.
Focusing on the 2015 project, was the government of the Virgin Islands offering a seat subsidy there?
What we decided at that time, after reviewing and sort of setting aside the 2014 project, we looked at the project, had discussions, and agreed that we do the subsidy up front, based on the same calculations, but we put it up front. And so whereas it would have been costing us in the region of maybe 15, the subsidy would just cost us just around $10 million in the subsidy, sorry. Whereas it would cost around about over $10 million if we are doing a seat subsidy. The way we approached it would cost us the $7 million. That was our maximum exposure.
I see. So by rather than having a seat subsidy that persisted during the lifetime of the project, by handing over 7 million at the beginning, the calculation was that the cost at the end would be less to the government of the Virgin Islands.
Substantially less, yes.
But it wasn't in the a subsidy normally is you fly a plane and we'll give you a subsidy of so much per plane or so much per seat or so much per unit of time. But this wasn't a subsidy in that sense, was it?
It was in a way, because it was based on the original estimate from the 2014 project, which carried a certain percentage per seat, but we decided that that was too high, so we needed to reduce it. By giving the subsidy up front, we were able to have the discussion to reduce it to the $7 million.
I understand that the maximum exposure under the framework agreement may have been 7 million as opposed to 10 million or some greater figure. I understand that, but the form of it on its face was not a subsidy. It wasn't a gift to run the airline. It was we'll come on to perhaps the precise legal nature of it, but it was an agreement. There were provisions in there whereby you could be paid back the $7 million.
The agreement was that we provide this, I call it a subsidy, I'll call it a subsidy at that point in time, towards getting the service to the British Virgin Islands. There were several discussions in it where if, successful, then the government would be paid back some monies. But the whole idea was to give the subsidy in order to get the flights to the British Virgin Islands.
I understand that was the intent of the £7 million up front, but the framework agreement was an agreement that BVI Airways launch and operate a commercial air service.
Yeah.
From originally, I think, from the 31st of October 2016. So, it was more complicated than this, but they were to provide an air service on particular terms. One term of which was that the BVI government paid sums up front. But I just don't see how that equates to a subsidy. Because there was nothing to subsidise. The contract was to provide an air service. Without the air service, there was nothing to subsidise.
Yes, but this was in anticipation of a service. If we had gone into the 2014 arrangement, for example, where we had made an arrangement to subsidise on a seat basis, before the airline started, we would have been in the same position before it started. Here we made a decision to provide a subsidy upfront for the whole 3-year program before it started.
Yes, but the form of the agreement was not, here's $7 million, put that towards running an airline. It was a more complicated agreement than that. For example, although this didn't form part of the framework agreement, we may come on to it, there was an earlier provision, which was not included in the agreement, for both parties to provide some of the capital needed to start the airline.
There was, in the discussion before, there was an assurance that one of the persons who were involved in BVI Airlines would put up to $6 million towards the project, right? But our understanding is that we are going to provide $7 million and they're going to provide a service. That $7 million will be our subsidy towards them. And they would have to provide the service at whatever cost it was to them.
Yeah, quite.
Yeah.
So this $7 million was towards the provision of a service of an airline.
Towards the provision of a service,
Yes.
yeah.
Okay, thank you very much.
Did you take legal advice at the time, Dr. Smith, as to whether the government was required to put the matter out to tender?
At this point in time, we discussed that, the financial secretary and myself, and we saw it as a subsidy and did not fall under the guidelines for being put out to bid. That is the protocols or even the finance regulations. And I've spoken about that in this paragraph as well.
So that was a view that you and the financial secretary came to.
Yes, we agreed on that.
Thank you. The other point we need to make before we move on to the next potential criticism is that you make the point that, and this is at your paragraph 9, Dr. Smith, that it was in the public interest to proceed with the project as quickly as possible in order to alleviate the difficulty and cost of travel to the BVI and to make the destination more competitive. Now, as I understand it, you had an affiliate of American Airlines, which was American Eagle, flying in, but that service then stopped in 2013.
I don't remember the exact date, but it stopped. We can go back before that.
But you deal with. I mean, we don't need to go back in detail, but okay. I can perhaps flag it up for the commissioner's note, because it's at paragraphs 8 and 9 of your witness statement, which is at page 3 of that. But you say there that since at least 2011, the government had identified that a direct air service between the BVI and the United States would greatly improve the prosperity of the BVI.
Again, as you know, sir, the economy of the British Virgin Islands depends on two things: financial services and tourism. Tourism is a very major part of the economy and was long before financial services. And that is where a lot of people are employed, both from the point of view of owning properties and working in properties. And so it was important for us to maintain that. If we could not get direct service into the BVI, we'd never be able to grow that service efficiently. And this is why we are so eager, so to speak, to get this service, both for the tourism point of view and also for the financial services point of view. Because when this facility was built, it was expected that there'll be people coming from various countries for arbitration here. And having a direct service will contribute greatly to them getting here to be able to do their business and get back to their homes.
I mean, we've heard evidence, Dr. Smith, that the plan was to extend the runway at the airport to enable direct flights to come in from places further away than Miami, because the airplanes could be bigger. That was the plan, and this project was intended to be a temporary measure. I think 3 and 5 years have been mentioned, whereby flights would come in regularly from the Miami hub, which would mitigate the lack of direct flights from elsewhere.
That's correct.
Over a relatively short period of time, but 3, 4, 5 years. That was the plan.
Yeah, because we saw it as necessary and urgent to continue to grow our economy.
Yes.
Because as I explained, tourism is the basis of the economy of the BVI.
Yes.
If we move on, no, I'm at paragraph 10 in your written response, please, Dr. Smith. The second criticism that's raised is that there was no invitation for competitive submissions, nor any examination of alternative solutions such as improving the ferry service. And your response can be broken down into two. First, you acknowledge that, yes, there was no invitation for competitive submissions, but you point to the fact that Cabinet considered that the proposal, and that's the air link from BVI to Miami, was the best solution to the immediate problem. And you've discussed some of that detail with the Commissioner just now. You then go on to say that there was other proposals had been considered. Firstly, the possibility of a direct flight to BVI and then to Dominica, and then from Dominica back to BVI and onward to Miami. When was that being considered?
That would have been perhaps a year or 2 years, or 2 years before. We looked at that, but we did not, when we examined it, we did not think that the owners of the service had the necessary capital backing to be able to do that.
So that must have been very shortly after you returned to office in 2011.
I can't give it the exact time, but after that, yes.
And by that time, was American Eagle still flying into BVI, or had it stopped?
I cannot remember the exact time when American Eagle stopped flying, but when it stopped flying, it was increased the problem that we were having in getting our people, our passengers, to the BVI. And despite the fact that we did have ferry operations going on between St. Thomas and Tortola, we had many discussions with the ferry operators on how to improve the service. We had many discussions with the US authorities about improving the service. But in the end, it was not sufficient. And you must remember also that St. Thomas is also a tourism destination. And we are, in a way, competing jurisdictions. And so,
I mean, I think we've heard evidence, Dr. Smith, that some research was done, and it was really just a customer choice as to what people coming here on vacation would prefer. And I think the fact that by going through USVI and getting onto a boat was not something which was attractive to tourists.
A few people would like that, who are adventurous.
Yes,
but the majority of tourists,
most of them just wanted to get here by some expedient means. Yes.
What you also say, Dr. Smith, is that there were talks with American Airlines and JetBlue, who gave an indication of interest, but that was dependent upon the runway being expanded.
Exactly. At that time, neither the planes which they now have, American Airlines, which can go to small islands, they did not have those planes at that time. And so that is why, we could not work with them until after we've had the airstrip expanded. But
these discussions with American Airlines, JetBlue, the investigations as to the ferry option, was that all going on before you settled on the BVI Airways link?
Yes.
If I take you to the third criticism, which has two elements to it. The first is that the operator parties failed to learn from and appeared entirely to ignore the experience of a previous attempt to launch an air service between Miami and the BVI, which was British Caribbean Airways in 1986. And the second is that the operator parties, and that's those who were behind BVI Airways, had little to no experience in establishing or operating an air link, because their backgrounds were in lobbying, law, investment, real estate, and banking. And we say that proper inquiries were not made into their experience, and or that inexperience was not taken into account in decisions made to proceed with the project with them. Now, in relation to British Caribbean Airways, we heard evidence from the former Financial Secretary, Neil Smith, on Friday about that. And your position, like his, is that the two ventures are not comparable at all.
Not at all.
Because there were specific reasons that British Caribbean failed.
There were specific reasons which were not represented in the Chief Auditor's report.
And those, as I understand it from the Financial Secretary, was that the arrival of American Airlines on the scene, and secondly, certain controversy surrounding British Caribbean Airways in any event. Certain controversies, yes.
I don't think we need to go into that. But
no, but Neil Smith set it out in his written response, so the Commissioner has the detail. And but obviously the arrival of an American Airlines flying directly in would also have put pressure on their business.
Yeah, I cannot recall the exact timing between American Airlines and it was American Eagle coming from Puerto Rico, but it was not American Eagle was coming in, and to have that other plane coming would have been useful because it was also coming from Turks and Caicos and possibly expanding. But I think mainly because of the other reason.
See.
Yeah.
But in terms of it would appear that from the perspective of the government, Caribbean Airways and what happened to Caribbean, that just simply wasn't relevant in your view.
Please repeat.
Was it your view that what happened to Caribbean Airways was not relevant to any decision you took in relation to BVI Airways?
Well, there was no indication that we could have from the experience of Caribbean Airways that would inform us how to go forward.
In relation to the second element of this potential criticism, you make the point that you don't agree that the operator parties lacked operational experience and that therefore this was too high a risk to take in granting them the requisite licenses. And that you said that that's a comment made by Mr. Jellock, who has also given evidence to the Commissioner. You say to the best of the government's knowledge, the parties were respected and successful businessmen. One had significant aircraft experience. And you then point to the success both in the BVI, and you give the example of the now defunct Air BVI, but also in elsewhere in the Caribbean of successful airlines being run by and owned by businessmen who don't have operational experience.
That is correct, but I also made a point that with British BVI Airways, they did have the experience. There's one, Mr. Willoughby was a pilot from the Air Force. He was and then into commercial business. And then the other two gentlemen were serious business people who had successful or unsuccessful businesses in America. So combined with that, his experience as a pilot, their experience in business, they could easily hire the other resources that they needed to be able to make the flight successful.
In terms of due diligence, was anybody in government tasked with doing due diligence on these individuals?
The Ministry of Finance, under the Financial Secretary, they do I think, and he gave evidence of that as far as I know.
But from your Premier and Minister of Finance, I mean, is that something that you get involved in at all?
No, the ministry does it. The Financial Secretary is my chief advisor on financial matters, and he would oversee these matters.
Now, obviously, Lester Hyman is in a slightly different position from the other three, but prior to the first approach in relation to the BVI Airways project, had you yourself encountered Mr. Bradley, Mr. Willoughby, and Mr. Wiseman?
No.
In terms of your conclusion that these three gentlemen were successful businessmen who were well respected. Did Mr. Hyman's views influence you in any way?
Mr. Hyman was an attorney with a major law firm in the United States who worked for us for over 30 years. He had an engagement as representing us in America in various matters for over 30 years. He also, and for the time that he worked with us, we were always satisfied with the service that he provided. He was also well known in the United States. He was at the firm Swidler Berlin, and he worked with several government departments and agencies in the United States. For example, attorney with the U.S. Securities and Exchange Commission, consultant with the federal agency. So he had vast experience. And because of that, and because of his experience with us, the 30 years that he worked with us, he was a trusted person as far as we were concerned.
So did he vouch for Mr. Bradley, Mr. Willoughby, and Mr. Wiseman to you?
Oh, yes.
We then move on in our fourth potential criticism to the joint engagement of technical experts. And what's said is that agreeing to a joint engagement of technical experts to examine feasibility of the project, instead of separately commissioning a full study to examine the possible option to address the airlift issues. Now, the feasibility study that's being referred to is the 6-cell study, which was done in July 2014. So the essence of the potential criticism, Dr. Smith, is the decision of to rather than have your own study, to essentially use an expert proposed or an independent body proposed by the operator parties, because that is what happened, isn't it? Did they put 6-cell forward to the government?
They did.
And how was the feasibility study paid for?
As I remember, we were supposed to split the costs, but I'm not sure exactly what happened in the end, how it happened. I think, did you ask the financial secretary about that? No?
Yes.
Okay, well, you would have known the answer. So in these instances where if I'm going to start a business, I have to do a feasibility study to see if it will work. And so these chaps we said to them, we need to see some study to say that this would work, would be efficient, and the service you provided would work. And so we agreed that there would be a feasibility study. There's no reason at that time for us to not expect them to provide a study that would be efficient and tell us what we need to know. And as far as we understood that service, the study showed that the service would have been satisfactory. And this is from the 2014 report, when it was reported. When my team at that point looked at it, this was before, there was a team headed by my private my secretary at the Premier's office, Mr. Broderick Penn. They all looked at it and they were satisfied about the study, but they were not satisfied about the costs. And so that's why we ended up not going with that project, and hence the review.
I mean, the point that you make in response to it is that the potential criticism proceeds on a complete misunderstanding, because the feasibility study was done not for the 2015 project, which was what went forward,
That's
but
correct.
for a 2014 project. But that still leaves the question, which is why go for a joint report rather than your own report to look at the feasibility of the project? But
if they were providing a service and we were looking around getting subsidized and said we can get this service, right? If a reputable company was suggested, which it was, we saw no reason why we should not engage with them and then each have our comments on what the study was and agree to it.
You see, I mean, if we look at your paragraph 40 of your witness statement to the arbitration, that's got a page numbers and it's page number 15. You explain there, and I just want to sort of just ask a little bit about how the 6L study was produced, or what the government saw. I think you set out in paragraph 40 that the operator parties had identified 6L as consulting group as the organisation to use, and they were supposed to provide an independent analysis, which came to the government in July 2014. Yes. You say at 41 that the final draft of the feasibility study was provided in September 2014. Just so that we're clear, in terms of the way 6L worked, did the government see drafts on which it could comment before the final version was issued?
I'm afraid I can't recall because I would not have seen them myself. But as you read a little while ago, the draft that was sent was reviewed by our team, BVI team, when comments made.
But to, I mean, I think in your witness statement to the arbitration and in the arbitration itself, I think that the government of the BVI's position was that there was, if we put it, that they raised a question mark over how that the final version was produced. But if we go to paragraph 45 of your witness statement, you say there, as I have explained, my government colleagues and I had always understood that 6L's feasibility study would be an independent one produced by leading experts in the field. This was of paramount importance to the government, as clearly we will be relying on 6L's feasibility study when deciding whether to proceed with and invest what turned out to be substantial sums in the 2015 project. So you seem to be saying there that actually the 6L study was still relevant to the decisions to participate in the 2015 project, even though, as you say in the criticism, it had been prepared for the 2014 project.
This paragraph is after the fact, right? After we had concluded the 2014 project, and after we'd started the 15 project, this criticism, because up until that point, we still were dealing with honorable gentlemen who were working with us, and we worked with them to get the service that we wanted. So this was the report that came after all of that.
If you could, I think there's, I hope one of the larger lever arch files there is the BVI Airways bundle. Mm-hmm. The two bigger ones, one of those should have BVI Airways on it.
Yeah.
If you could turn up, please, page 680 in that bundle, or 681, please.
681.
Commissioner, whilst Dr. Smith's turning up the page, can I just record that Mr. Dennis QC has joined the hearing, which I hope that his technical difficulties have been resolved.
Thank you so much for that information, Councillor.
I'm taking you, Dr. Smith, to the arbitration award. And at these pages, the arbitrator set out the substantive parts of the framework agreement, which was what the agreement which governed the 2015 project. If you look at under the heading preamble and then goes to the third paragraph, which reads, whereas the MOU, Memorandum of Understanding, contemplates that subject to a satisfactory feasibility study, the government and Castleton would enter into an agreement. And then the next paragraph reads, whereas the government has reviewed the results of the feasibility study, is in agreement with the conclusions set forth therein, and has determined that it is in the best interest of the Virgin Lines to proceed with the project and grant the right to develop and consummate the project upon the terms and subject to the conditions herein set forth. Could you just help us with this? In terms of the reference there to the feasibility study, is that a reference to the 6-cell study?
That would be a reference to the 6-cell study.
So it appears to still be playing a part in the framework agreement, at least.
Yes, because at that we did not question the results of the 6-cell study until after. So at this point, even though when we had it done in 2014, we considered the project would have been too expensive based on all that, it still was relevant because we bargained, so to speak, with them to reduce the cost of the service overhead.
Yes.
But it's still relevant, and I said it would have been a satisfactory, the service would work. That's what.
If we take that through to the fifth criticism, which is at paragraph 14 in the warning letter, Dr. Smith.
Paragraph, please.
Paragraph 14, please, Dr. Smith.
14.
That is failing to adopt the BDO advice, which called for a more balanced financial arrangement. None of the recommendations made in the BDO report was adopted at all. And you again point in response to that BDO's report was on the 2014 project rather than the 2015 project, which was the project that you actually went forward with. You say that the government did adopt aspects of the advice from the BDO report for purposes of the 2015 project, such as limiting the exposure of government for the new project. In terms of, can you doing your best to assist the Commissioner? It's right, isn't it, that the BDO report was much more pessimistic about the prospects than 6-cell had been?
They were more pessimistic in the 2014 project, yes.
Yes.
And this is why we shelved the project. But we thought it was still pertinent with reviewing some of the conditions and the recommendations of the BDO's advice. That's what we did. One of them was to reduce the overall cost. And there were other recommendations which was implemented, which the Financial Secretary would probably have told you about.
Now, where you say that it reduced your exposure, it was that under the 2014 agreement, you would have been giving 10 million.
That is correct, yeah.
Whereas the threshold that the government set itself was 7 million.
7 million, that's correct.
But one of the points, as we understand it, that the BDO report made was that government was required to bear the costs, all the costs and the risks, whereas the operator parties were guaranteed the returns. And the advice was from BDO was that the financial terms needed to be renegotiated to more appropriately apportion risk and reward. in what way was that taken on board?
Well, that I can tell you, the one way I know for sure is that we reduced overall cost to government. That was the main thing.
I'm sorry, Dr. Smith, because I think I interrupted.
Okay.
Carry on.
The first thing is that we reduced that to $7 million. There were other aspects of that report that were reviewed, but I would not remember the details of that because I was not involved in those discussions.
But that doesn't respond to the point made by Mr. Rawat. Mr. Rawat's point was that, I mean, the BDO report did say these costs are high, and you reduced them in 2015. But they made, as I understand it, a discrete point that all of the commercial risk, whether it was 10 million or as it was 7 million, rested upon the BVI government, and none of the commercial risk lay on the operators.
I understand that. But what we were negotiating for was a service to the BVI and giving a subsidy for that service. As we negotiated and discussed it, that subsidy was $7 million. We did not, it wasn't an attempt to get money back from the flight. We did not own any part of BVI Airways. We were just receiving a service from them. We thought the service was important for the BVI's economy, as I mentioned earlier. Tourism is the main factor beyond driver economy, and we saw the need to do something to help to support that.
I understand that, but all of the commercial risk lay upon BVIG, none on the operators. And normally the commercial risk would be more evenly spread than that, because by spreading the commercial risk, the chances are that the project, the chances of the project being successful are increased.
I understand that, but this is why we set our maximum, and this is why we recently went ahead with the project, because they indicated we expected them to, because if they're providing a service, they should provide the service at whatever cost the service is once we agree on a price. But that was reinforced by the message that the principals would inject at least $6 million. So that reinforced it, but it did not, in our minds, remove the responsibility of the operator parties to provide a service at whatever the cost was, because that was what we agreed to.
In terms of the $6 million that the operators might have put in, there was no obligation for them to put that in. So that $6 million was not a commercial risk for them. The commercial risk was in respect of your $7 million, because if at the end of the preparation period, everything just stopped, you would be $7 million down, and they wouldn't be anything down.
We understood that, but as far as we were concerned, there was an arrangement for them to produce the flights that would bring on visitors to the BVI, and we would subsidize it, right? And so we expected them to do that. And it was not a matter of just say we're going to put in 2 million or 6 million. They're supposed to produce the service at whatever cost that service was.
Yes, thank you.
So the understanding of the government by the time that the framework agreement was signed was that you would give $7 million maximum, and they would then, and in return for the $7 million, they would then provide a service, which would be a direct flight from Miami into the BVI.
That's correct.
Bringing tourists.
Yeah.
I mean, sorry to interrupt, Mr. Abbott. I think to be accurate, at the time of the framework agreement, I mean, correct me if I'm wrong, the agreement was $5 million, because after $5 million, there were going to be planes in the air. Another $2 million to come, but the $2 million under the framework agreement, as it originally was, that was to be paid after the flights had started.
That is correct, yes.
If it turned out that the cost of that service overall was, for the sake of argument, 9 million, it would be down to the operator parties to find the additional funds.
That is correct.
Because from the BVI government's perspective, the operator parties were going to get a fixed sum, and they had contracted to provide a service in return for that fixed sum.
That's correct.
You indicated, Dr. Smith, that there was no expectation that you would get the money back, but the expectation was that there would be benefits in other ways.
That is correct.
To the twin pillars of the BVI economy.
Correct.
I think this is obviously was envisaged as a short-term measure whilst the runway was extended at the airport. But were there any studies done to show what the economic benefit of the short-term measure would be?
I don't recall any studies, but I won't be able to put my hands on studies of tourism arrivals because we had those studies done through the Tourist Board. But I'm sure I can request something like that to show what the tourism figures were, how they were increasing and decreasing, how we compare to other countries who had direct airlift from the United States.
But you don't remember, if you like, the government commissioning a study to say, okay, if BVI Airways institute a flight, fly a certain number of times into the BVI a week, what will the benefit be in terms of numbers of additional tourists and the economic benefit, and also in terms of the financial services sector as well?
No, I don't recall a study like that, but we knew based on the arrival of passengers to BVI, also the arrival of passengers to other destinations with airlift, with proper airlift, that there was a considerable difference. We looked at St. Thomas, for example, right? And so it was important for us to, continue to build our tourism sector. We had a population that's growing. We had challenges with our financial services sector. And so it was important to build up our tourism sector.
Could I move on then, Dr. Smith, just to the sixth, I think it's the fifth, the sixth criticism, I think. Which was the position of Mr. Hyman. And if I read it, it says Lester Hyman was listed as a representative on the BVI government's team in the draft report for a meeting on 26 August 2015, in which the parties solidified the terms for moving the project forward. This was in spite of his apparent alignment with the operator parties. The Auditor General noted that in assuming dual roles in the BVI Airways venture, Mr. Hyman operated in conflict of interest as his fiduciary obligations to the BVI government appeared to be superseded by his personal interest in the project. If the dual role of Mr. Hyman was not known, then it suggests that proper due diligence was not done. You set out, and you've done it also in your witness statement and earlier in your evidence, but that Mr. Hyman had a long-standing relationship dating back to 1987 with the BVI government. He had retired from a renowned US law firm of Swidler and Berlin, Swidler spelled S-W-I-D-L-E-R, and Berlin. His career had involved also working for various US agencies, and that he had in the BVI itself been involved with the community, as for example, as a founding member of the board of H.L. Stout Community College. You say that against that background, there was no reason to carry out additional due diligence on Mr. Hyman in 2015, because it would have been inconceivable that, given his background and experience and his position, that you would not need to be aware if there was a conflict of interest or the potential for such conflict, and therefore the need to act to avoid it. You say at 16 that there was nothing in the history, and given Mr. Hyman's involvement and his involvement in the project, that would have alerted the government and yourself to the fact that, and I'll choose my words carefully, that he had interests in both camps. You say you direct the commissioner to your witness statement where you have given further detail of it. But does it come to this, Dr. Smith, that you only knew of the roles that Mr. Hyman was playing once the project had collapsed?
That is true.
And I think it's right, isn't it? He was involved in negotiating the framework agreement.
He was, yes.
When that was being negotiated, and as we understand it from Mr. Smith, the BVI negotiating team was himself, Clive Smith and Russell Harrigan.
That is correct, yes.
But when negotiations were going on, who did you consider Mr. Hyman to be representing?
He was part of our team, and during that meeting.
Now, once framework agreement was in place, one of the elements of it was that the BVI government could have a government representative on the BVI Airways board.
That's correct, yes.
And that was Mr. Geluk.
Mr. Geluk, yes.
Now, his evidence to the commissioner was that he went to a board meeting and was introduced to Mr. Hyman at that meeting as a director of BVI Airways. Were you ever made aware of that?
If that happened, he certainly did not inform me of that. So I was not, if that was the case, I did not know of it.
I mean, I think, you know whether Mr. Geluk, it doesn't appear to be from the information we have, that gave evidence in the arbitration proceedings?
I know that I don't know where it is.
I don't think he's listed amongst those who provided witness statements, so that would suggest he wasn't that involved in it.
I can't recall, actually.
If you give me a moment, please. And you?
Yes, I think on second thoughts, he did give some evidence.
I see. Yeah. All right. We'll follow that up after this hearing. Now, what you do say in your witness statements that you later learned, or I think at the time that you were providing the witness statement, you learned, and this was the statement for the arbitration, that you learned that Mr. Hyman had accepted a directorship of BVI Airways, and also of a company called Colchester, which had a share of BVI Airways. Is that right?
Yes.
Can I take you to page 7?
Just to be frank, I learned that after the whole process collapsed.
Yes. So that information came to your knowledge, yes, in the process of preparing for the arbitration?
No, some of it came to my knowledge in June of 2017, when the leader of the opposition asked a question, and I had to provide certain information for him.
But before the collapse of the project, during the course of the project, my understanding from your both your response to the COI and your witness statement is that you considered, you thought that Mr. Hyman was acting on behalf of the BVI government in all of this.
Of course we did.
And there came a point after the collapse of the project when you understood that he wasn't, that he was, he had at least a foot in each camp.
That was after.
Afterwards, yes, afterwards. But as Mr. Rowett said, in the sense that he was a director of BVI Airways, perhaps more than 1 foot in that camp, but at least both of the feet were not in BVIG's camp. Yes.
Could I just ask you to turn up in that lever arch file, page 767, please, Dr. Smith, just the one that you have open.
767?
Yes, please. It's part of the sort of arbitration decision. And if you look at paragraph 37.6, what the arbitrator records is actually at the outset of Mr. Hyman's involvement in what became the Avro project, and that's what the arbitrator called it. Dr. Smith and the BVI government could only have thought that Mr. Hyman was with the airline, not the government, or at most a go-between. The arbitrator then sets out a January 9th, 2014 message to yourself, where in writing, Mr. Hyman refers to the new airline that we proposed to you. And he included an attachment that refers to our airline proposal for the BVI. If you turn over to the next page, the arbitrator, and I won't set it out, then continues to set out the arbitrator makes the point that it's not possible to read that letter and conclude it's from a lawyer representing the BVI government as to the new airline. The arbitrator then sets out.
Could you tell me which page you're reading?
Yes, I'm on 768, please.
Okay.
So I'm just summarising paragraphs 37.8. At 37.9, the arbitrator refers to the memorandum of understanding. So that's at the 2014 project stage. And then says at the end, when asked about this memorandum, the final version of which is referenced in the preamble to the framework agreement, Dr. Smith testified as follows, and then sets out some questions and answers put to you at the arbitration, which concludes with you confirming on page 769 that Mr. Hyman was the go-between. And the arbitrator at 37.10 says that's consistent with Mr. Hyman's own description of his role. And if you look at 37.11, what the arbitrator then makes the point that during the course of the project, Mr. Hyman quite visibly appears representing BVI Airways, not the BVI government, at least twice during the course of the project, once directly adverse to the BVI government entity. If you turn to page 770, at 37.12, the arbitrator sets out details of a dispute between BVI Airways and the BVI Airports Authority, and explains that the BVI Airports Authority is solely owned by the BVI government. It's operated by government employees, including Clive Smith, who was on the negotiating team. And the arbitrator concludes that paragraph with this: in that dispute between BVI Airways and the BVI Airports Authority, Mr. Hyman represented BVI Airways. And so you have a conclusion by the arbitrator that at worse, on the evidence that was available to you at the time, and it takes us back to 2014, the conclusion could only have been that Mr. Hyman was representing the operator parties. And at best, the best that can be said is that he was a go-between between the two parties.
Well, he was the person that was representing the BVI government to the operator parties. If you call that go-between, then that's go-between, but he was the person that was representing myself, government of the BVI, in the discussions with the operator parties.
If we take that last example where he is...
And this example that you mentioned, I had no knowledge that he was in this
dispute
meeting
with the Airports Authority.
No, I had no knowledge of that.
That was never brought to your attention at
No.
any time before the framework agreement was signed or afterwards?
No, and I listened to the evidence that Mr. Smith gave the other day, and I don't think he had any evidence either. And he would be the one who would be relaying this information to me.
But I mean, it seems a bit strange because you had in your negotiating team a representative of the Airports Authority.
Yes.
And yet information wasn't being shared across government. Because, I mean, you're essentially negotiating to bring an airline into the airport. Mm-hmm. The authority gets into dispute with the airline. Nobody appears to tell the financial secretary, and therefore the Premier and the Minister of Finance doesn't find out that Lester Hyman, who, from your perspective, plays an important role in this process, represented the other side.
Well, I'm not sure how they saw it, but as I said before, this was not a discussion that I knew about. And from what I understood, not a discussion that my financial secretary knew about, was one who basically advises me on most financial matters.
Commissioner, I'm just moving on to another topic, and I wonder if we could have a short break for the stenographer.
Yes, certainly. Dr. Smith, you may remember from last time, but we have a stenographer. He just needs a break every hour or so. So we'll take a 5-minute break now and then come back and hear the rest of your evidence.
Thank you
very much. Thank you, Mr. Rowett.
Thank you, Commissioner. Dr. Smith, if we turn to, we're on paragraph 17 of the written response that you have provided. The seventh potential criticism that's raised of you as Premier and Minister of Finance is allowing the motive and urgent pushing from the operator parties to dictate government's involvement in the venture. Only a month after the government had rejected the proposal, you entered into further correspondence with Mr. Hyman in circumstances in which you agreed in evidence communication was emotive and that Mr. Hyman was a friend. Your response to that is to say that you have many friends, including Mr. Hyman, who you had known for 20 years, and that friendship did not in any way influence the decision to enter into an agreement for services to be provided by BVI Airways. You deny that the motive and urgent pushing of the operator parties, which is something that the Auditor General raised in her report in terms of the tone of some of the correspondence that was sent to you. But you deny that that influenced government's decision at all. You make the point that the BVI government was proceeding on good faith. And in reliance, it seems, and tell me if I've misunderstood this, on the fact that Mr. Hyman had been the BVI government's US representative for a significant period of time. Is that right?
Yes.
Go on, please.
Mr. Hyman, as I said before, had been working with the BVI for quite a long time, over 30 years. And we had no reason to have a problem with any of the work he did for us. It was always good work, apart from the reputation he had in the States. So we had no reason to believe that he'd not be working for us. And as a matter of fact, if you go to page 184, the same document.
Yes, in your written response.
Yes.
Yes.
You notice that it says, by way of example, Lester stated in an email to me, Bruce knew from the beginning and knows now that I am involved in this project solely in my capacity as United States legal counsel for the BVI. And so, with all that, or the fact that we had a good history record of him performing for BVI, etc., we expected him to continue to perform well for us. And we did not know of this duplicity until afterwards.
I see. What you also say, just is that you point to the fact that the 2014 project was turned down, and that for the 2015 project, the primary change that government sought and obtained was that its maximum commitment, the 7 million, was the upper limit, and that was set before you proceeded with the 2015 project. Is that right?
I mentioned that because to show that no matter what he said or how he said it, if we thought that the project was not good enough, it was not good enough. That's why we turned it down. It didn't matter that he was a good friend or anything. We looked at the project, reviewed it, and decided it was not satisfactory and turned it down. He came with a different project, and we looked at it. It was a new version, and we looked at it. And when we looked at it, and we agreed that we'd set a maximum at $7 million, and the other things that the financial secretary would have been included in that agreement. Then we said, okay, we will now, pursue it. Pursue it, not meaning to just lose $7 million and not worry about it, because we were, keep putting this money in for service. When it did not materialize, that's when we got, and later on when it would not materialize, then we engaged Mr. Martin Kenny to look into the matter for government when I was still Chief Minister.
But when you set off on this course, what your evidence, the commissioner, is that, as you say, you were not putting in the money to lose it. What you were putting the money is to see planes begin to land in the BVI.
Exactly, not to, of course, yes.
And you again rely on your full statement for the arbitration, which gives further details of your interaction with in this case, Mr. Hyman. The next potential criticism that's raised is put this way: failing to adopt or even properly consider the amendments made by the Attorney General in the drafts agreements that would have afforded greater protection of the BVI government's interest in the venture. The framework agreement signed on the 7th of December 2015 included a provision that BVI Airways was to use its commercially reasonable efforts to launch an operator commercial air service by 31st of October 2016. The Attorney General sought to have that term removed from the agreement as it did not favour the government's interests. Given Mr. Hyman's conflict of interest and the Attorney General's role as a public servant, taking the advice of Mr. Hyman over that of the Attorney General was inconsistent with the principles of good governance and was not in the public interest. The first point you make in response, Dr. Smith, is that at no time were you aware that Mr. Hyman was in a position of conflict.
That's correct.
You say and repeat that it only became apparent after the collapse of the project, and prior to that you say it had been your sincere belief, based on his long-standing professional relationship with the BVI, that he was acting in the best interest of the BVI government. You therefore respected his advice as a hitherto trusted legal advisor and representative of the government, and having considered both his and the Attorney General's advice, you say, I ultimately came to the understanding that the phrase commercially reasonable efforts was a standard phrase used in business, which at the time did not seem to be a game changer. Now, in reaching that view, and was it ultimately your decision as Premier and Minister of Finance to accept that the term commercially reasonable efforts should be included in the framework agreement?
Let me explain. The person who was the chief negotiator here was my financial secretary, Mr. Smith. And I know he gave evidence that he was considered other lawyers and asked them for their opinion of this race, including Mr. Hyman. And they were all of the opinion that it was satisfactory. Right? And so based on that, we decided that we'd go along with this program.
So was it the...
And have that phrase included in the agreement, yeah.
So in terms of how you were advised, then, was the work in terms of consulting legal advisors undertaken by the Financial Secretary? Is that right?
Yes.
And did the Financial Secretary then come to you and said, this is the legal advice we have, we need to make a decision?
Yes, yes.
And do you recall whether Mr. Smith told you that the operator parties were insisting on having the term commercially reasonable efforts put into the framework agreement?
I don't recall you haven't said that, but if they were actually insisting, they wanted it in, and he approached these legal folk to get an opinion, and they gave him that opinion. He shared that opinion with me, and we decided to go forward.
Now, you've put the term game changer in quotes. Is that because it was a word that others used to you? This is in your warning response, in your response at 18.
No, it was, it didn't seem that it would change the outcome of what we're searching for.
I see, thank you. The ninth potential criticism, Dr. Smith, takes us back to evidence you gave or questions that were put to you by the Commissioner earlier, which is about the financial commitment that the operator parties indicated they would give. And it's written as a failure to secure written commitment from the operator parties of their financial input into the venture, and to ensure that this obligation was incorporated into the terms of the framework agreement. And you say there, and you've mentioned it already, that in several emails you had a commitment putting up to $6 million in the project. And it was on the basis of that commitment that Mr. Smith, Financial Secretary, then travelled to commence negotiations. You accept that it wasn't included in the final agreement, but say that again, the government of the Virgin Islands and yourself were acting in good faith and expected the operator parties to do the same. And you point to what the government's involvement in this project was. It's the point you've made that government's involvement was $7 million. What the operator parties agreed to do was to provide a service at any cost. So it was ultimately for them, as you've said, if there was a difference in cost, then they would have to find the difference.
That is true. And we fully expected them to do this, to provide a service. In hindsight, it would have been good if we had included the $6 million in the agreement. But I'm not sure why we didn't. I suppose it was because we were expecting a service from them, and we believed that what they said that they would do, that they would do. Right?
So you proceeded on the basis that you had an assurance, yes, that an additional $6 million would come into the airways.
Of course, yes.
And you said you don't know why that did not find its way into the final framework agreement. But at any time, did the operator party say that they would not be putting any money in?
No, not to my knowledge.
Do you recall any discussion within the BVI team, the government's team, about whether or not this should go into the framework agreement?
No, I don't recall a discussion. As I said, the team was, working with Mr. Hyman and others to prepare the document. And that was unfortunately not put in. It would have, if it had been put in, it would have saved us. At least we would have been able to claim some money back, maybe, because then the process would have gone on towards hopefully completing the flight, right? But the essence of the agreement was that we put in this $7 million maximum and that they would provide the flight. We fully expected them to do this.
But Dr. Smith, you say that you expected them to put the $6 million in, and in your written response, you say the commitment of the operator parties was to provide this service at whatever cost that would be to them.
Right.
But under the agreement, neither of those things was an obligation placed on the operator parties. Under the agreement, they were not committed to provide a service at whatever cost. They were committed, as we've just seen, simply to make commercially reasonable efforts, which is a different kettle of fish. And secondly, under the agreement, they weren't committed to putting in $6 million. All of the commercial commitment was on one side of the balance, really.
Yes, but on many occasions, they made this statement, this commitment that they would be putting in this money.
But it was not a legally binding commitment.
It was not in there, I agree. But that was one of the bases on which we went forward, expecting that once we had made progress, that we'd be delivering a service to the BVI, right? And we expected that service, and that's why we went along. And that's why we continue to work with them to provide that service.
Yes, thank you.
One final point you make, Dr. Smith, and I just want to put it on the record, but it's your paragraph 20, but what you make the point is that there came a point in time when the operator parties continued to demand more money from the BVI government. And you say, having received our financial commitment in full, I refused to comply. And that led to the rescission of the decision of the agreement in 2017. If we move on to criticism, the 10th potential criticism, which was that effectively removing the performance requirement from the agreement that required BVI Airways to commence flights before receiving the final 2 million government advance. So as matters changed, as the Commissioner pointed out, the 5 million was going to be advanced, and then there would be another 2 million once flights started. I think you explain, and we've heard from this from Mr. Neil Smith, that, and indeed it's in the Auditor General, the government experienced difficulties securing a letter of credit.
That's correct.
And ultimately that led to the decision to forward and advance the remaining sums so that BVI Airways had all the money before flights could commence. And in fact, I think the date by which flights would commence was put back in time.
Okay, actually, this is the way it happened. We had difficulty getting the letter of credit. And it took it caused some delays, and eventually got the signature bank and make a deposit in the signature bank. And at that point, we agreed to put forward the monies up to the $5 million. The $2 million was not included at that point to take forward. It was after we got to a point where we had the company. There were airplanes, there were flight arrangements, there was arrangements at the airport here in Tortola. They had the okay and the go-ahead from ASI, which is the UK approval agency. And they were in the process of getting the agency approval from the FAA. At that point, after putting in $5 million and seeing the progress almost there, we considered it and said, okay, let us do this, get them over the hump, and then we should see the plane flying. As a matter of fact, the airport officials in Miami made a statement that they were ready to fly, but it was retracted by BVI Airways personnel.
But again, when the $2 million was paid over, all the risk was on the BVI government side. I mean, as you say, you say in your written response, advancing the money meant that planes leased could now fly. Given where things stood at the time, the government and I had every reason to believe the airline was actually about to commence operation.
That's correct.
But there was nothing sought in response to the 2 million. For example, a guarantee that they would fly next Tuesday or next week or next month. They were given the £2 million and you really in the hope that they would fly.
Well, at that point, many of the conditions for flight was in place,
yes.
were in place. Right? And they were just waiting now on the approval from the FAA. So we had every expectation that the flight would begin.
But it was a hope. It wasn't a contractual commitment by the operators.
It was an expectation based on the agreement that we had before, that they would provide a service once we made the first contribution of 7 million.
Yes, thank you.
And just in terms of the detail of how the 2 million was paid over, we've heard from Mr. Smith, but obviously it was put into an escrow account. a decision was ultimately made to pay it in advance of the dates that had been agreed. Did you sanction as Minister of Finance the decision to make those payments in advance?
Yes, I did, and for the reasons I just explained. Yeah.
Can you just explain, Dr. Smith, why those weren't decisions that needed to go back to Cabinet?
Because the laws, the finance laws, allowed for the Premier and the Minister of Finance to make such commitments when it was necessary.
And in this case, it was
for the progress of the British Virgin Islands.
To get it over the hump, so to speak.
Yes.
Thank you. The 11th criticism that's potential criticisms raised is relates to this, and it's something that we canvass with Mr. Smith. But you assign the individual in charge of the government's finance, that's the financial secretary, to serve as the primary facilitator for implementation. So resulting in there being no higher financial authority to question or prevent that individual's decision to make early and complete payments to BVI Airways, which was contrary to Cabinet authorization. You say what then goes on is the fact that you, as Minister of Finance, authorised this payment to be made early without any guarantee of performance by the operator parties, and indeed before authorisation for the flights had been received, is evidence of poor financial management and poor governance. You, in response, said that firstly, you were Premier, Minister of Finance, but also Minister for Tourism. And your priority was to find an effective solution to airlift to the BVI. Following Cabinet's approval, you turned the implementation of the project over to the Financial Secretary, who you saw as competent and experienced, and who would be able to take decisions quickly after conferring with you. What you say is that it appeared to you that it was the right decision to take, given where things stood at the time. And there's no basis for any criticism of bad governance or poor financial management, because for the reasons why the early payment was made. Now, I think that's again what you saw in your view as the need when you were getting to that sort of stage where 5 million had been paid over, to use the additional 2 million to try and effectively get the project to the starting line, I suppose.
Yes, I saw progress. I saw evidence of a plane. The plane was even here in BVI. I saw evidence of the ability to fly, given the assurances from the British, regulators, and also the evidence of them getting, quite forward into getting the approval from the FAA regulators. As a matter of fact, I wrote to both the regulators in support, because I said we needed the service. And so I would, make a letter to them to encourage them to work with the airline so that we can get the approval to fly. All of this in order to get the approvals and get the plane flying as quickly as possible. The longer we waited for the approvals, the more difficult it became, hence my involvement.
An element of the potential criticism is the position of Mr. Smith. So Neil Smith found himself obviously as the public officer tasked with negotiating the BVI Airways project, liaising with the operator parties, and trying to ensure a successful outcome. His role as financial secretary, on the other hand, as a custodian of the public purse. Did you yourself at the time appreciate that might raise a conflict of interest for Mr. Smith?
I thought that he would be suitably placed to be able to perform that role, knowing exactly what the regulations were and exactly where we wanted to go.
But did you see a conflict?
No, I did not see a conflict at that time. No.
Did anyone raise with you that there might be a potential conflict?
Nobody raised that.
Was it ever discussed in Cabinet at any point?
I don't recall a discussion in cabinet on that matter, but everybody knew, all the members of cabinet knew.
That Mr. Smith was in that role.
Exactly.
There is a 12th potential criticism, which was that there was no adequate financial oversight in the project, and in particular, financial statements were not obtained, and the operator's offer of disclosing the financial statements in the US was not taken up. Now, you again rely on the fact that matters have been delegated to Mr. Smith as financial secretary, and you rightly say that he addressed this issue in his own examination before the commission. You accept that financial information should have been made available to the BVI government. And you say, it's my understanding that financial statements were available, albeit they were inadequate. You say, though, we did, however, take up the offer to review the records and ask Mr. Mark Forte of the law firm of Conyers, Dillon Pearman, who had by then been instructed by a government in the matter to do just that. And you explain that those efforts are documented at paragraph 135 of your witness statement to the arbitration. However, looking at that, and this is also in the Auditor General's report, Mr. Forte became involved or was instructed in June 2017.
Correct. Yes.
And so that was after matters started to go in the wrong direction.
But it was after matters had started to go in the wrong direction when they invited the financial secretary to review the records as well. It was after the last $2 million was paid out. And we thought, the first response to that is that I should ask one of the people at the board, that is Mr. what's his name again? Jellock, to write to the company to ask for these records, because as a director, he was supposed to be receiving those records. He wrote to the company, but did not get a response. And that is when I instructed Mr. Forte to work with me. And one of among the other things, he also visited and looked at the records of the company, which he said were far from adequate.
But this was really after the balloon had gone up.
That is correct.
Yes.
Yeah.
The criticism really is that the records weren't looked at, even when we've had evidence there was an offer to the BVI government to go to Florida to see the records, but the records were not looked at. One set of records was sent by the operators, and they were patently inadequate. And you say that even after things had gone wrong and Mr. Forte went to look, the accounts were inadequate then. That's unfortunate in terms of governance, not very good.
Not very good. What I would say is that we were trying to, as you understood, we were trying to get this service started, and hence we did put forward the $2 million at the end, right? Fully expecting to get a service. When this did not happen, then we said, okay, let us engage Mr. Forte to look at the record, but also to see if there was some way possible for them to work with them to continue the operation and have flights. That was his mission.
But good governance might have dictated that before things went badly wrong, efforts were taken to look at where the 5 and then 7 million that the BVI government had given to the operators, what they'd done with it. And that was not done.
The financial secretary did have some records, but they were not as complete as they should have been.
I think the evidence is that they were patently inadequate.
Right.
Mr. Smith's evidence to the commissioner was that she accepted what he did get was limited. It came late, and he did not consider it sufficient. But what he also said, and this is reflected in the award, was that there was an offer to him to come to Fort Lauderdale to look at the records, and the arbitrator recorded that it was common ground that whilst the project was still active and alive, the bookkeeper was still on the payroll, that Mr. Smith was invited to inspect all of Colchester Aviation and BVI Airways financial books and records where they were physically kept in Fort Lauderdale, Florida. And this was what we canvassed this with Neil Smith, because what's recorded is he was puzzled that the BVI government would not permit him to take up that invitation. Could you just help with why he wasn't allowed to go to Fort Lauderdale?
To my recollection, this happened after the payment of the $2 million, right? I, at that point, said, I need somebody independent. So this is why I asked one of the directors who would, by law, should receive the statements. And after that failed, then I asked Mr. Forte to review it for me.
But up until that point, the effect is that the BVI government had not been supplied, even though the framework agreement, I think, provided for this, but that you had not been provided with adequate financial statements, with correct. The result, therefore, that you couldn't maintain adequate financial oversight.
The Ministry of Finance were receiving the statements. And when I knew of that, just before the $2 million that's when we had that discussion. And we agreed to put forward the $2 million with expectation that we'll be able to continue the program, have the flights and have the records correct.
But in effect, that financial information, the indication of how ultimately 7 million was being spent, the BVI government was only able to get hold of it in June 2017, following Mr. Forte's instruction.
That is correct.
If we go to
But I would like to say that, of course, once we had discovered what was going on, and realizing that they had not met their commitment, and finding out reasons why and other faults in the arrangement, then we engaged the firm Martin Kenny to look into it, to recover the money that was spent.
I understand that, Dr. Smith. Yeah. But if you had understood that the financial statements were inadequate earlier, that may have been a flag that things were not going as well as they might.
I agree, if I had understood earlier.
Yes. Yes.
Dr. Smith, I'm going to take the last criticism shortly, and I'll summarize it in very shortly. That effectively it comes down to the BVI government spent 7.2 million, because the 2 million is an extra 200,000 that was advanced to BVI Airways, but without any public benefit. Now, that's the nub of the criticism. Some of the points that you make in response, and it is a detailed response in your written response, are ones that you've made already, including the efforts that were made subsequent to the collapse of the project. But one point you make is that expenditure of 7.2 million for a service of direct flights between the BVI and Miami was, in principle, money well spent. You point to the fact that you had, by the end of it, there were planes, there was, as you've said, staff had been engaged, licenses had been received, and so from the perspective of the government, you and yourself, there was a belief that BVI Airways was ready to commence a service that you had bargained and paid for. What you say, I think, brought the agreement to an end was that operator parties wanted more money from the government, and this was something that you were not willing to do.
Correct.
You point to the fact that you had the financial secretary's chief negotiator. You had Mr. Geluk, I think, on the board of directors of BVI Airways, and the government had done all it could to ensure that best practices were followed in its efforts to obtain direct flight service to the territory. And so, bringing some of these points together, you say you acted in the public interest.
I maintain that.
Of course. I mean, what's important, I think, for the record, because of course people will read the transcript and maybe following these proceedings, is that you have given a detailed written response, which the Commissioner will consider. But if, and you also point to the fact that the arbitrator, in terms of its findings as to the way government had acted, you say that the arbitrator's findings support that government acted responsibly in bringing immediate end to this situation once you realize that it had become inimical to the public good. And as we are aware, there are obviously ongoing proceedings in relation to the BVI Airways project. But stepping from it now, you start off your response by saying that in principle, spending money in order to establish a direct line flight from Miami into the BVI, even for a short period of time, you say is in principle a good idea. But what would you do different now, Dr. Smith?
I think it was a good idea, because it was something that was necessary and would be useful to the British Virgin Islands tourism and economic development. I put in place measures. You had someone as the chief negotiator, board of directors, deputy CEO of BDO, which is an accounting firm in the country. So we had people in place who could do the responsibility to ensure that the program was going right. However, it didn't. So what would I do now? First of all, as I said earlier, the investment was a good idea, but a greater commitment in the form of, as opposed to saying commercially reasonable, where you were influenced by Mr. Hyman, something more direct that would ensure that they had a liability, which would have, which is what the Attorney General was asking. But as we explained earlier, Mr. Hyman was a trusted representative for us. The Financial Secretary considered opinion from other lawyers, and then we agreed to go with that position. Unfortunately, we were at that point. But because of all that, and because of the duplicity involved, it was necessary for us to engage Mr. Martin Kenny to try to recover the money that was spent.
Thank you. Can I move on to the second project we have to ask you about today, Dr. Smith, and that's the port development project. You can put that larger lever arch file away if you could, please. Again, if I give some context, in relation to this project, Dr. Smith, you were again sent a warning letter on the 13th of September, directed, again, raising potential criticisms directed towards your role as Premier and Minister of Finance. You have provided, again, a written response, but can you confirm that you are content for that written response to form part of the evidence before the Commission?
Yes.
Thank you. If I take you through the potential criticisms that are raised. The first relates to, we heard from Honourable Vanterpool this morning. If one likes the second stage of the project, once your administration had taken office, which was that obviously November 2011 through to July 2012, there was a situation where the Ministry of Communication and Works under Honourable Vanterpool was leading on the project. There came a point in or around mid-2012 when the Ministry of Finance took over and instigated a tender process.
Right.
Can you help the Commissioner with why it was decided necessary for the Ministry of Finance to become involved?
It was after the program had been started by the Honourable Vanterpool that the protocols were agreed to sign on and agreed to by the British Virgin government. And it was then decided or indicated that what was happening at that point was not in line with the protocols. And so we decided to have the Ministry of Finance step in and start the process again.
Up until that point, how aware were you of what stage the Ministry of Communications and Works had reached with the project?
The Minister for Communication Works had gone to meetings in Miami, meet with the Cruise Association. And it was impressed upon him that something needed to be done about the pier and reception area in Road Harbour. Because if something was not done, then the cruise ships would be forced to reduce the numbers of passengers and trips to the BVI. As cruise tourism had assumed an important part of our economy of our tourism product, he saw the urgency to get on with having something done about improving the situation, that is a widening by the dock, etc. Right? And so I am not sure how the bids were acquired initially, but I know that at some point, at the point where the protocols were put in place, it was decided that we needed to take a step back and move forward in a planned way.
Now, the protocols were signed on the 23rd of April 2012.
Yeah.
So obviously the discussions and negotiations leading up to the protocols being signed would have paralleled the work that Honourable Vanterpool was doing in relation to the port development project. Did anyone raise any concerns with you as to the manner in which the project was being progressed?
No, when initially before the Ministry of Finance,
yes,
no one raised any.
I'm sorry, could you bring the microphone closer to you?
About it. Not that I can remember.
I mean, the reason I ask, and I can take you to it if you need it, is that Honourable Vanterpool's then permanent secretary told the Public Accounts Committee in 2014 that she did have discussions with you raising concerns about the procedures. Do you recall any such discussions?
I don't recall, actually.
One of the other issues that relates to and that arises in relation to that first phase when Honourable Vanterpool was leading on the project, so to speak, was that the extent to which the Port Authority were involved, because there is evidence to suggest that, in fact, despite being the decision-making body, they were not involved in the process at all. And it was all essentially being led by Honourable Vanterpool and Claude Skelton-Klein as his advisor. At the time that the Ministry of Finance became involved, which was July 2012, was any consideration given at that point to making the Port Authority the lead agency on the project?
The time when Honourable Vanterpool was leading the discussion and the way forward on the renovation of the pier, he indicated to the Port Authority in his capacity as Minister of the Ports that from a policy decision that he wanted to go in a different direction from a policy decision.
That was his indication given. How was that? Who was that communicated to?
To the board.
To the board.
Yes.
That was so. He told the board, "I want to take this from a policy position in a different direction." Was Cabinet involved in that at all?
Cabinet was involved to the point that the decision, the recommendation about the persons who should be selected was brought to Cabinet. I do not recall the details of when it was brought to Cabinet, at what point, because that was a long time ago, but I know it was brought to Cabinet. And the Cabinet agreed for the program to go forward. The governor was in Cabinet. His question was, would there be any loans, as far as I can recall? And then we continued that progress until we had the protocols coming into place. And then we said, okay, we have to step back now and review where we are going and put it forward as a proper bid.
I see. So whilst Honourable Vanterpool was leading the project, what was brought to Cabinet was, or what was sought from Cabinet was approval of the company that had been selected to take the project forward. But then what interrupted things was the need to comply with the protocol. Yes,
as I recall. But the minister was also in communication with the Port Authority. As a matter of fact, the first thing he did was to say we want to go in a different direction. Then there was another statement where he said to them, okay, my policy is we're not going to continue with Disney. We want to go in a different direction. What I found interesting was that even as he was saying that, the board was, after he said that, progressing the Disney project, right? And but he persevered, brought it to the Cabinet, and then we were directed to change direction after the protocols and went out in a proper bidding process.
So I mean, it appears that that it was the protocols that brought a halt to the selected company that had been selected under the process put in place by Honourable Vanterpool taking matters forward, right? Because Cabinet decided you had to do it under a tender process. Is that right?
Yes.
If we look at what's set out is that, and this is in relation to the tender process, the first element of the criticism is that the expedited tender process led by the Ministry of Finance lacked transparency and fairness. And what's said is that the length of time allowed for the process was inadequate. The provisions in the invitation for expression of interest mirrored the previously accepted proposal from TPP, which created an unfair advantage. So TPP was, under the process put in place by Honourable Vanterpool, had been the successful bidder, so to speak. And then obviously once a decision had been made to move to a tender process, had to resubmit a bid. Now, in terms of your response, Dr. Smith, you say, first of all, you were unaware that the invitation for expressions of interest mirrored the previously accepted proposal. That was not something you were told.
No, I didn't. I was not aware of that. No.
I wonder if you could just pull the microphone a little closer to yourself, Dr. Smith.
I was not aware of that.
Thank you. But you don't consider that the process was lacked transparency and fairness overall, is that right?
No, because the financial secretary engaged two very significant firms who were very experienced in matters of contract law, etc. That is Baker McKenzie and PricewaterhouseCoopers, who actually advised him or advising him of how to go about this. And they were, they gave him all the advice that was necessary, and he followed that advice and went out to tender. I think that the time period for expression of interest was adequate. It was at least 2 weeks. It was adequate.
I mean, to remind you, I think Mr. Smith has given evidence twice about this. Neil Smith has, and he certainly, when he gave evidence last week, there are two periods. The first was the time allowed for expressions of interest, which started off as 2 weeks, but ultimately was from the 16th of August to the 12th of September, which I think on his evidence, he said was adequate, having regard to, for example, the kind of timeframes that the comparable timeframes or recommended timeframes. But what he accepted was that when you take the time to submit a more formulated proposal with technical and financial information, a tender bid, giving tenderers, as was given between the 12th of September 2021 and the 11th of October, which was just 4 weeks, was too short. Mr. Smith's view was that it should have been at least 6 to 8 weeks. Given that your then financial secretary is expressing that view now, does that make you less certain that the process was transparent and fair?
No. When I read the report of the Auditor General, if you can take it back to that, it's
yes, of course. It's in. If you take the two smaller bundles, it's one that is bundle labeled bundle 1 on the front.
Okay.
I think the page you might be looking for is right at the back. If you go to page 535, please, Dr. Smith.
What is happening here is that this report by the Auditor General has some conflicts. I'll tell you why. The project that was envisioned at that point had 3 phases. One, there was sent out for expression of interest. And then there was a bid process. But the bid process was I can't find it right now. But the bid process actually started off with a concept. The persons who made the approaches would present a concept of what the whole development would look like. A concept doesn't take that long to produce. After the concept would have happened, then they'll be invited to make presentations, and then one will be selected to continue to the development of the proposal for the establishment of the facility. But let me find the that's number 50 in the chief auditor's report.
50 or 15?
50.
50. Are you looking at Roman numeral 1, Dr. Smith,
Yes.
where it says submitted concept?
Concept must be self-financing. So that really indicated that the initial step at that point was supposed to be concept design submitted. Now, the way it's in this document here, it is part of the first process, but it's not actually, it's the second process.
I see. So it's in your view, therefore, expressions of interest for 2 weeks and a concept process, concept design within 4 would be an acceptable time frame.
I think so. I have this, yeah, because that is true.
Sorry, if I could give me a moment, please.
And Dr. Smith, can you pull the microphone closer to you? This is the stenographer. Thank you very much.
If we move on then just to the second criticism, please, or second element of it, and that is that the fact that the team assessing the tenders included Claude Skelton-Klein, who had by that time already established a relationship with TPP and its principals in light of his involvement in the prior process. And this created an obvious conflict of interest, which was not given any proper consideration by the Minister of Finance. Now, again, to give it context, so Mr. Skelton-Klein, as we understand it, was appointed as a consultant to the Minister of Communication and Works.
That's correct, yes.
And he was, on evidence, very involved in the project. What then happened was that when a tender process was decided upon, you had on the evidence an evaluation committee which looked at the proposals that were received, and that was chaired by the Deputy Finance Secretary, Mr. Gaskin. And Mr. Gaskin has limited recollection of events. He does remember that he was Deputy Financial Secretary. But once it had gone through that evaluation, it then went to a second committee chaired by the Financial Secretary. And Mr. Skelton-Klein was on that committee. And that committee then looked at the more detailed submission that came in from 2 entities, one of whom was TPP. Now, you point to the fact that on that, what you've called the Tenders Committee, you had Baker McKenzie, you had PwC, and you also had, I think it's Dr. Drexel Glasgow.
That's correct, yes.
Doing the technical side of matters. And those were independent persons who were involved with the process. And you say Claude Skelton-Klein was there as the representative of the Minister of Communication and Works, and so representing the government of the, and so representing the interests of the government of the Virgin Islands. And therefore, you say his involvement in prior involvement would have had, doesn't give rise to a conflict of interest. Is that right?
No, I didn't see that. Yeah. No, I saw no conflict.
Yeah. Were you aware at the time, Dr. Smith, that Mr. Skelton-Klein was involved on the Tenders Committee?
No, I was not aware of it at the time. But being aware and seeing who were involved in the process, these reputable firms who actually were advising, these are the people who were advising the financial secretary about the process. Right? They would have picked up any discrepancy that they thought there would have been, but they were quite satisfied. And Mr. Klein was there representing the ministry. So if there was any information that was needed, he would be able to provide it. But these 3 people are the ones who made the selections, as far as I understand.
the evidence that Mr. Gaskin gave to the Public Accounts Committee at the time was that when the Financial Secretary was absent, Mr. Skelton-Klein would actually chair the Tenders Committee. That would not have been something that you were aware of anyway.
No, I would not have.
I mean, I think your evidence is you weren't actually even aware that Mr. Skelton-Klein was on that committee. What you rely on is the fact that there were others there who would be the safeguard. Thank you. The third point that's raised is that, and this is a point I've alluded to, is that the Port Authority Board, as the decision-making body, was excluded from the process. And that was throughout. So even when the Honourable Vanterpool was leading on the project, and then when the Ministry of Finance was involved, it was not until later that the project was handed back to the Port Authority after the tender process had been terminated. Now, what's said is that as Minister of Finance, you had an obligation to safeguard the autonomy of the board. As Premier, you had an obligation to ensure that a minister in your cabinet did not act in such a way as to compromise the autonomy of the board. And you've set out, and I think you've explained this already, but the role that Honourable Vanterpool had played, you've explained, for example, that he had met with the FCCA Miami, that he understood that that there was a different approach needed, and therefore he'd informed the board of that policy decision, and had informed them of various other matters, such as the cancellation of the Disney project, which was the original project under the predecessor administration. You then say that you don't understand the details of what followed thereafter, but you understand it was a process where there were 3 groups taking part, and which ended with TPP being selected as a successful bidder. You mention, which you have done already, the fact that although Honourable Vanterpool was taking the project in a different direction, as recorded by the Auditor General, plans for the original project was submitted to Town and Country Planning. You've noted that. You then go on to explain, as you have done, the reason why it had to start again was because the protocols for effective management came into play. And you note that this was a process in which the board of the BVI Ports Authority was represented. Could you just assist the Commissioner? How, as you, so far as you can recall it, Dr. Smith, was the board represented?
I am not sure whether it was the chairman of the board or the managing director. I can't. I have no recall of that.
Do you know whether that either chairman or managing director was on the tenders committee, or?
I can't recall it, but I know this, that the Port Authority is not a body unto itself. It still reports to the government, to the cabinet of the BVI. And so if something is not going right, there's what is called the Central Tenders Board, who has a responsibility to review things and make sure that they're corrected. And then, after that's done, then they would hand it back over to the ministry. And this is essentially the process that was being followed.
By the Ministry of Finance?
Yes.
So the process that was being followed from July 2012 until the point when it had to be terminated was that the Ministry of Finance would oversee the tender process.
Correct, yes.
And then it would be handed to the Ports Authority to deliver.
That is correct, yes. Well, through the minister, but to the Port Authority.
Of course, yes. But there is evidence that would suggest that the minister may, or it might be said that the minister's job is policy direction.
Yes.
The board would have responsibility for executing the detail. So
I agree.
would you agree with that?
Yes.
But taking that point then, there is a distinction between the two roles of minister and board. During your tenure as Premier and Minister of Finance, what steps did you take to safeguard the autonomy of boards?
Well, speaking about this, all boards function as they're supposed to function, as to my knowledge, right? Certainly. But referring to this passage here, it was the responsibility of central government to make sure that things are happening correctly. And that is why, after the protocols and so, the Financial Secretary got involved and got the Central Tenders Board to do that, review the program and do the publishing for the tenders and all that. So once that had been corrected, then it would all be turned back over to the ministry, which indeed it was afterwards.
But I think by ministry, you mean it would go to the Ports Authority. Is that right?
Yes, it did, yeah, to the Port Authority.
But generally, did you give the ministers in your cabinet any guidance as to how they should approach boards, statutory boards, so as to preserve the autonomy of those statutory boards?
This was established procedure that every minister understood and worked on. But before the protocols came in, there was, and at that point, there was an urgency that the Minister Vanterpool saw. There was an urgency. Having been to sea trade, having been to the Cruise Association in Florida, he saw this urgency because he was told at that point that if something was not done, the visits by the cruise ships would decrease, the numbers would decrease. And this was a part of the industry that the country had accepted and needed. It was a vital part of the industry, and so therefore it was necessary to do something. I know when he started off, he was very enthusiastic and tried to get it done because he saw the urgency. But then when we realized that there should be a different tender process, he had no hesitation in saying, okay, let's go ahead with the process, let the Central Tenders Board do their job.
But you said in terms of maintaining the autonomy of the board, it was established procedure. But could you just tell the Commissioner what was the established procedure under your tenure as Premier and Minister of Finance?
Each ministry, not each ministry, several ministries had statutory bodies attached to their ministry, right? Each statutory body had their own rules and regulations, which the particular minister would know about. And the statutory body continued to operate as a statutory body with policy direction from the minister. I know this for a fact. The BVI Electricity was one of the major statutory bodies, and that continued to operate as a statutory body. The tourist board continued to operate as a statutory body, so all the ministers knew what their approach was to statutory body. I think, and it's in the law, right? And so while, as I said before, each statutory body may have a different set of rules and regulations, these were all followed, as far as I can recall, except for this one.
Certainly, in terms of, from the ministers in your cabinet, what they would have known is that their role was policy.
Yes.
It wasn't operational.
Right.
Thank you. If we move on quickly, Dr. Smith, just to the last potential criticism that's raised, which is that, and it arises in this way, as part of the tender process, tenderers were required to show that, or strongly encouraged to have a local partner. And ultimately, I think it came to that you would have to have a 20% involvement of a local partner. The submission from Tortola Port Partners named the BVI Investment Club as its local partner. And what the potential criticism says is the involvement of BVI Investment Club raised potential issues of conflict of interest, of which the Minister of Finance should have been aware and which would have been relevant to consideration of the TPP proposal. Those arise in two ways. The principal of PFK BVI Limited, a firm engaged to prepare a business case for the initial TPP government partnership, was also president of and a public figure for the BVI Investment Club, and declarations of interest for election candidates published and gazetted on 10th of October 2011 showed more than one elected member with shareholding interests in subsidiary companies owned by the BVI Investment Club. Now, the PFK's involvement had been in relation to when TPP was going around the first time under the umbrella of Honourable Vanterpool's work. But your answer is short, which is that despite the chairman of PFK having other interests, which are many, he is the sole owner of that company, which had no involvement with BVI Investment Club. And therefore, you don't think it's right to infer that that company derived any benefit because he was a member of the investment club, nor that any other member of the club benefited because his company was engaged. You say that members of the BVI Investment Club do not hold interest in all of the activities of the club. None, to your knowledge, had interest in the port project. PFK BVI was just doing a job and not as part of the BVI Investment Club. I think perhaps it boils down to one question, though, Dr. Smith, and that is that you have a tenderer coming forward, and this TPP, who've already been through a selection process, albeit one that was not a tender process, and they're now going through again and have reached the tenders committee. They have partnered with the investment club. And isn't the question this, did anyone at the time consider, to your knowledge, whether that raised a potential conflict of interest?
To my knowledge, there was no conflict of interest because of the following. First of all, let me look at your PKF to start with, right? The PKF, the chairman of PKF, he's a businessman in this territory with many interests. The BVI is a small place. The number of people who could be involved in processes like this is a small number. And it would be wrong to penalize somebody for other interests when he's being required to do a particular job. He was doing this, PKF was doing this as PKF, not as part of the investment club at all. And the investment club was not involved. Further, as far as I know, even though the company had named the Total Investment Club as a partner, I cannot recall that there was any document signed that was given that showed that this was happening.
But do you know if the tenders committee, in looking at and you've called it a concept design, but in looking at what was being submitted by those seeking to be successful under the tender process, had in mind the conflicts of interest?
I don't see why they should, not to my knowledge, because further, right? As I said, as far as I know, there was nothing signed between those two companies. And the other thing is that, as far as I can recall, no member of the investment club had any interest in the ports. The investment club is a club which has several different companies, And members are involved in companies that they choose to be involved in. For example, some members are with a telephone company. Some members are with a land development company. So it's difficult to say that any member would have gained from that, since none of them were involved in that company.
Thank you. Can I conclude with one final topic? You may be aware that the Commissioner has heard evidence in relation to the perimeter wall that was built around Elmore Stout High School, and that includes evidence from Myron Walwyn. Now, your party returned to government on the 7th of November 2011. When would the election have been due after that?
We have a 4-year term. So it was November 11, 15, November 15. That sounds like it, right?
Now, as we understand it, you decided to call an election on the 8th of June 2015. Is that right?
Yes.
When did you inform your cabinet, of which Mr. Walwyn was a member, that you would be calling an election?
I honestly cannot recall that, but I know that it was due at that point and we called another election. But at this point, I cannot recall, some time ago, I cannot recall when I said to them, we're going to have an election at that time.
Would it have been shortly before you called the election on the 8th of June? Would it have been shortly before then?
It would have been shortly before.
Thank you. Commissioner, I've concluded my questions. Can I finish by thanking Dr. Smith for returning to give evidence, and also apologise that we delayed the start of his evidence, and it's been a bit of a long session. But I conclude finally by thanking him as well for the way in which he has given his evidence this evening.
Yes, can I add my thanks, Dr. Smith, both for your time and the way in which you've given your evidence, which has been very helpful. Thank you very much. It's all right.
10 o'clock tomorrow, Commissioner.
Thank you.